Hey everybody. So this week I'm going to talk about something that I guess I'm mildly uncomfortable to talk about, but I had a question on a Patreon and I wanted to follow up on it, and so I'm finally getting to doing that. The reason I say I'm mildly uncomfortable is because I have to start with a disclaimer, which is number one, I am not a lawyer, and number two, nothing I'm going to say here is legal advice. This is purely opinion. The question from Edward Stonehill: curious if prior to working officially with Marvel, if you had worked on any characters unofficially, fan art. If so, were these pieces you had accepted as being just for yourself, or were you able to sell the originals? I'm assuming it is more of a thing whether Marvel or a company like Wizards of the Coast would enforce their copyright or not. So to answer the specific question of if I've done fan art, besides pieces that I've done that are officially licensed or commissioned by the person who owns the intellectual property, yes, I haven't done a whole lot of it, and it's something that I've always had kind of complicated feelings about. But I've shared some paintings on this channel that I think would certainly fall into the category. And I, at different points in my career, have done it for different reasons. I'm probably going to talk more about that kind of at the end. But I think the substance of this question is more about like, how okay is it to do this stuff? And so I will start with that early in my career, for many years of my career actually, I had what I think is a common understanding that you're protected under the First Amendment to do whatever artwork you want to do, and the only time that you might run into legal issues is when commerce comes into play. And specifically, the way I understood that was sale of originals is fine, but it's when you start getting into reproductions, prints and books and things like that that you run into trouble. I have since been persuaded that this is incorrect, but I also think a lot of this is really murky territory. It seems like the laws are a little bit fuzzy in some respects, and the amount of actual cases that have gone to trial and reached a decision by a judge are fairly few as far as I can tell. A lot of cases where somebody actually gets sued over basically doing a painting of a character that they don't have the rights to do are very few. Most of the time it seems like if there is any kind of action brought at all, it'll be a cease and desist letter. If it goes to the point of actually reaching somebody like taking legal action, those cases tend to settle before a decision is reached, which means that as far as I understand these things, there's a limited amount of actual precedent to explain what is and is not okay. And so instead, a lot of the way that this law is followed is just kind of common understanding. And something else to note is that a lot of people will talk about fair use as though that itself is a law. Fair use is a defense. It's not a law. It's just a way that you defend yourself against being held liable for violating the law. So if what you're doing is within what is generally understood to be fair use, you would have to make that case in court, and then a judge would rule if it was fair use or not. I have had some informal conversations with a copyright lawyer about this stuff in response to some relatively recent situations that have come up. I remember one of them was an artist who had plagiarized another artist's work in a piece that they created for a client, and the work that they plagiarized was a piece of fan art, and that raised an interesting kind of debate with some people as to who did the wrong thing when and all that. And obviously everybody agreed that plagiarizing the art was bad. What struck me as interesting, the point that this lawyer was making, that it took me a long time to really kind of accept, but I do at this point get his point, was that the act of creation itself is the violation. And so this person who had done the fan art was technically in the wrong, and that artwork, they did not properly own it because they don't own the intellectual property that the artwork was based on. And in this lawyer's opinion, that put the ownership of the artwork in the hand of the intellectual property holder. I don't know if anybody was ever actually asserting that, but that will actually come up in something else that I'm going to mention. So the other, I've got a list of notes here because this is a weedy topic and I don't want to forget anything. The other thing I want to say here about this is, if the letter of the law is that the act of creation is the actual violation, there is also just the way that this stuff actually plays out in the real world. And there are a lot of considerations. One thing is that for anyone to take legal action, first they have to be aware. Usually when people get on the radar of these companies is not even just showing the work, but creating some type of product, prints and books. As I mentioned before, I always understood this to be the line that you do not cross. And that tends to be more for practical reasons, as that is where this can become something that a company or a corporation feels the need to defend and assert their rights and protect their copyright, protect their intellectual property. And you obviously don't want to be in that position of being threatened legal action by an enormous corporation like Disney or somebody. So the other thing to weigh against that is that when these enormous corporations do decide to come down and drop the legal hammer on an artist, it tends to look bad. There is a PR cost. And so as I've seen it, there doesn't seem to be a real eagerness on anybody's part to go out and find and sue artists who are violating copyright at like artist alleys at conventions and things like that. Over the years, there have been a few times when concerns have been raised that that might happen, that lawyers are going to start walking around artist alley dropping cease and desists on people's tables. I just have a hard time believing that that would ever be worth, even if it was something that Disney or Marvel or whoever felt so aggrieved by this that they wanted to do that. I feel like the backlash, how bad that would look, prevents it from happening. But legally they could, as far as I understand. So there's a few cases that I'm aware of that I think kind of like relate to this, and that kind of relate to some of the things that I've been talking about. I don't believe this to be an exhaustive list, but these are just the ones that I've picked up on over the years. And we'll start with Disney versus that random daycare, which is a almost kind of like urban legend at this point. But this is a true story. I'm going to refer to some of my notes here. This was in 1989. That there was, it was actually 3 daycares in Florida that had created these murals of Disney characters. And Disney decided to issue a cease and desist. They didn't sue them. They were just threatening to sue them, as I understand it. And the daycare, not wanting to get sued, decided to paint over the murals and actually replace them with Hanna-Barbera characters, because Hanna-Barbera recognized that Disney looked like a major asshole in this situation, and they stepped in and they were like, you can use our characters for free. We don't care. We love kids. We're not going to tell a daycare they can't do this. And people still remember this story, what is it, 3 decades, more than 3 decades later. So I think that's like kind of a good example of where Disney was in their rights to do this, but publicly it just feels unacceptable. And I don't know if there's been another case happening since then of something like that. But the next one that came to my mind was Gary Friedrich, who was a writer for Marvel who co-created the character Ghost Rider. I don't want to state any facts wrong, and I apologize. Please hit me in the comments with any corrections if I get anything wrong in any of this. But my understanding of this one is that when the Marvel movies were just really starting to kind of ramp up in the early 2000s, Gary Friedrich brought a lawsuit saying that he should have partial ownership or ownership of the character as one of its creators. And Marvel countersued because, first of all, they did not want to grant that right. And second, Friedrich had been selling Ghost Rider merch at tables at conventions for years. And Marvel was like, hey, we've looked the other way on this, as we didn't want to, again, like go after, person who had created work for them. But now you're making it our problem. So that's just, I think, typically what happens when a corporation gets sued, is that they countersue if they have any grounds to do so. So this kicked around the court for, I believe, 6 years, and ultimately it was decided, and then it went to appeals, and then Friedrich and Marvel reached a settlement. And I don't believe that was ever made public. I don't know if we really know kind of how that all ended up, but it certainly was a messy and sounds like pretty grueling process that Friedrich went through on that. So the next one was an artist named Sean Gordon Murphy, who did a book called Wolverine ABCs that was basically, it was like a little convention sketchbook. And my understanding is that it was never actually for sale originally. It was just something that this artist did with the intention of promotional, giving it away. I believe he said that some of the people that he gave copies to were people who worked at Marvel, so he was not trying to like sneak anything past anyone. But he ultimately did end up having some leftover copies once he'd done all of the promotional giveaway stuff that he wanted to do with it, and he did decide to sell some at a convention, and then got a cease and desist from Marvel, where my understanding is that they actually didn't say just that they wanted him to stop selling it, but that they now owned the artwork and the rights, and that they were potentially going to make their own book using his work without any compensation, and basically that they owned it. 2011 or 2012, I guess, is when this was going on. And it seems like they ultimately came to an agreement where basically everybody was just gonna just set it aside and let it go. And Marvel wasn't gonna assert their right to ownership. But that does tie back into what this lawyer friend of mine was talking about, where just the fact that you have created something that violates someone else's intellectual property rights potentially might give them the ability to do exactly what Marvel was saying that they were going to do here. I suppose that it would have required going to court over it, I guess. I don't know. But it definitely sounds like it would have sucked for anybody involved in this to have to deal with. Ultimately, they have the muscle to kind of lean on you and say, do you really want to go to court with us? We can just go ahead and agree that we own this, right? We can print this. But in any case, they were able to come to an agreement where they did not do that. And I thought it was interesting. I found that Sean Gordon Murphy had written a statement about this at the time. I'm going to skip a lot of this, but just this one section where he says, I can't really be angry at Marvel for their actions. They were in the right, even though some things at conventions are tolerated. It's still technically wrong. My mistake was being a higher profile artist and making a themed book out of Marvel characters. I was surprised that it led to the threat of legal action, but it's not my call to make. I apologize to Marvel up and down, and I still feel incredibly stupid for what I did. My mistake was thinking that it was no big deal, because most people in comics don't think it's a big deal. But most people haven't dealt with Marvel like I have, and that's what fueled my involvement in this entire issue. So, yeah. which ultimately it sounds like it did work out for everybody, but it also sounds like it was a pretty unpleasant process to go through. I also know another artist who I'm not going to name because I don't think any of this was ever public, but another artist I know who did a lot of work for Marvel and was also very high profile, who was selling prints online. And this was many years ago when this was all still kind of like the Wild West of selling things on the internet, selling prints online, and got a similar kind of cease and desist from Marvel. In this case, Marvel did actually own the rights to that work because it was done as work for hire for them. But this artist was selling prints feeling they had a right to sell prints of their own work as well. Marvel came in and said, you can't do that. And I remember hearing this story firsthand when I was like very early in my career, just starting off. And so that always left an impression on me as to really take that stuff seriously, which when people come to me sometimes and ask if I have prints of my Marvel masterpieces and things like that, and I always say no. I know other people do it. I know I could probably get away with it. I don't want to deal with that, so I don't do it. I try to follow my contracts and just leave it at that. One other case that I thought was interesting, it doesn't have to do with fan art in the same sense as the stuff with Marvel and Disney and that, but there was an artist, I remember hearing about this right around the same time as the Marvel ABCs and the Gary Friedrich cases, because this is all like right around the same time. There's an artist named Daniel Moore who was, I understand this, for many decades doing paintings of a football team, the Alabama Crimson Tide. Yeah, okay, I guess Crimson Tide is the team. I don't know. In any case, he'd been doing these paintings for years, and in 2005, the university filed a lawsuit saying that depicting the uniforms was violating their own rights, and that he wasn't allowed to use their logos or uniforms and colors in his work. And he fought back against that. There was a ruling in 2009, so 4 years of fighting this. A judge ruled that he was allowed to use the uniforms in his paintings, but he didn't have the right to make merchandise of those paintings. So the university appealed that he had the right to do the paintings. He appealed his right to be able to merchandise it. And I believe it was another 3 years later, I think it was in 2012, that this was finally decided that he was fully within his rights to not only do the paintings, but also merchandise. This is one of the few cases of somebody getting sued over I believe it's a trademark infringement here, and persevering to the point that a judge ruled and said that it was okay. And this actually required not just the judge ruling, but also then going through the appeals process as well, which is good news for artists. I don't know how analogous a football team's uniforms and logo is to, say, painting of Spider-Man or something like that, but it definitely illustrates that this is a murky and contested territory. I know that there are fine artists who have been in and out of court over this kind of stuff. I remember reading that Andy Warhol got sued all the time, and he would always settle. He'd give artwork to whoever was suing him, and that's my understanding of how that was resolved. And there are other artists who would do work that was kind of like pop culture referencing or influencer related. And similarly, I think that these things tended to reach settlement instead of reach a verdict. My personal feeling, given all that, is I never want to have to be in a courtroom dealing with any of this stuff. And so I tend to be very conservative and cautious when it comes to anything that might be perceived as overstepping that line of what is actionable. Any work that I have created that is of a fan art nature, I've tended to try to do it in a way that was not hewing too closely to the original, which is something that I think is also worth talking about, is the intention behind doing it. I'm going to come back to that. Something else that just occurred to me is fan art, as I've been describing it here, has been about artwork depicting characters or properties that are already kind of like a fixed visual presentation. But that is not the entirety of fan art. And another situation that comes to my mind is Donato Giancola has done a lot of paintings of Middle Earth, and the essentially like based on Lord of the Rings and other Tolkien stories and books. And my understanding is, in conversations that I've had with him, that these were not, that the source material is books. It's written words, and so there is no fixed visual representation of it the way that Mickey Mouse or Spider-Man is a fixed visual representation of what this character looks like, the costume, the design, and everything. But when you're doing works that are fan art based on a literary source, or I suppose if you were doing fan art based on music or something like that, anything where it's taking something non-visual and then creating a visual representation of it, I believe that you have a much stronger shield against any kind of claim, because there is an actual artistic creative process in just visualizing something which is otherwise only verbally described or written in words. And in any of those cases, like reproducing the written words or reproducing anything that was like a fixed protected expression, that would be in violation of copyright. But making pictures on someone else's story that has never been, or that maybe even that did not originate, because of course Lord of the Rings has been dramatized and visualized many times, but it originates, you can go back to that source material and create your own expression of it. So I tend to believe that culturally fan art is kind of like a mutually beneficial, almost like a symbiotic relationship. It's fan building for these properties at no expense to them. It is a way for the people who love these stories and properties to kind of like engage with it. And there is such a long history of fan contributions to these very kind of rich worlds and what we think of as intellectual properties. There's just so much of these franchises stand on the shoulders of what fans have created and done over the years to keep them alive and carry them forward during long stretches of time where they were kind of dormant. And I think that we also live in a franchise-heavy culture, which is something that is clearly apparent if you just look at the state of movies and how so much of the landscape of the movies that are made and released today, especially anything big budget, tends to be built on existing properties and franchises. And there's always been this to some degree, or at least for my whole lifetime, this has been some amount of remakes and sequels were to be expected. But over the past, say, 30 years, it has truly changed to the point that that is now the norm. And people do kind of hunger for and seek out something different. But at the same time, those big franchise releases do very well. They make a lot of money. And there's a reason, is because people are already connected to this and people already have a deep love of these worlds and stories and characters. And that familiarity brings people in. And in a way, these movies sell themselves. If you have a new Marvel movie coming out or you have a new Star Wars movie coming out, maybe we're reaching a point, I don't know, where people are getting a little fatigued by that. But clearly for many, many years, it was enough to just say, there's a new thing coming out featuring these characters that you know and love, or from this creator, from this world, and people are going to go see it. And I think that is similarly at play when people are making fan art. I was thinking about kind of like the pros and cons, going back to the question of if I've done fan art. And there's pluses and minuses here. On the one hand, if you set aside just genuine love and joy of the thing, which I really do believe is often just the pure motivation for making fan art. But if you look at creators who do this as a lot of their business, and that business interest is at least mingled in there, creating work based on familiar characters and properties is a relatively easy sell if you're trying to sell originals or prints or things like that, because you are taking a shortcut past the need to connect with people and make them familiar with and care about the work that you're doing. You still have to do that stuff, but you are taking an enormous benefit from the work that others have done before you by, if you're doing a painting of Batman, people already have a connection to this character. They already have a lot of feelings and appreciation for and fandom for this character. And so whatever you decide to do with Batman is building off of that, is tapping into that. And so there is a real benefit financially to doing this work, which is what I think some people kind of like have concerns about. And I understand that's complicated. But just as a on a pro-con level here, that is a reason why this is an attractive thing to do. And in addition to that, if you want to work for the companies that make these properties, this is actually a viable way to get in the door. A lot of companies want to hire people who they definitely feel secure that this person understands what they do and can deliver. And a lot of the time, the best way to get that attention seems to be to actually do it, to make samples that feature those characters or that look indistinguishable from the product that this company produces, to demonstrate and prove that you can be trusted to produce for them. On the other side, the cons here, there's the obvious one, which is what a lot of this video has been about, which is you're going to be severely limited in how much you're able to sell or reproduce these works. It's something that might be overlooked in the short term or on a one-off, but if you turn around and see that you've spent the past 10 years doing fan work and you don't own any of it, in the way that you can't make a book, you're always at risk doing prints and things like that. I don't know how much like making a book is really a moneymaker anymore, if it ever was. But still, just the fact that you are going to be severely limited, just the fact that so much of the work that I've done has been through clients that insist on work for hire. And that limits me if I ever want to make a book of my work. And this is officially licensed stuff. I would have to get permission from and would not always get permission from those clients. Or in some cases, I know that I have contracts with some clients that say, if you ever want to use this work in a book, you're allowed to, but it can only be X% of the material. So, if you make a book, it can't be all just, let's say I wouldn't be able to do a book that's like the Magic the Gathering art of David Palumbo, because that would be against my contract. But I would be able to do a book that's the art of David Palumbo that might feature a section of that with approvals, and as long as it falls within certain restrictions, copyright notices on it and everything like that. If you're doing it off the books, if you're doing it as fan art, you might not even have those concessions. You don't really have anyone to seek permission from, so that puts you in an even tighter spot as far as being able to ever do any kind of downstream reproductions of this work. And I think there's a little bit more hazy, but for me, in a way, more concerning aspect, which is the more you do fan art as your thing, the more you are limiting and discarding avenues of creating your own personal brand or creating your own thing that you do own entirely. And over time, because people who gravitate towards the fan art, a lot of what they're interested in, they're going to be interested in your depiction, but they're also there because of the subject for the most part. And I think that long term, it's very beneficial to cultivate a following and build your own market for your personal work. And that's something that is very difficult to do. You're in a much stronger position and have more independence the more you own your own stuff and the more what you do belongs to you. And if you're a person who your personal brand supersedes any intellectual properties that you work on, I think that puts you in a very strong position as an artist. And one example I always think of here is Phil Hale, who truly a distinct voice, brilliant artist whose work really is recognizable when you see it, and who developed and built his career in a way that his work is unmistakably his, to the point that when he would work on other people's properties, it almost is secondary to the look of his work. And I always think specifically of a Batman cover that Phil Hale did, where it's Batman, but I see Phil Hale first and I see Batman second. And Batman is such a powerful, strong symbol, such an iconic character, that it's hard for me to think of many artists who could do a Batman where you see the artist's hand before you see that it's a Batman painting. And that to me is remarkable. And I think that brings me around to the final point I want to make, which is if you are going to do fan art, to really give a lot of thought to what you want to contribute and what you want to say with it. Why does this need to be made? And I think that for me, everybody might have their own motivations. Speaking personally, I always appreciate work that does something new or different or unexpected. And so if you're going to do fan art of something that is a widely recognized, wildly popular property, I think that it's valuable to reach within yourself and find what is your personal expression that you can bring to this. What can you do with this that you feel has been missing or that hasn't been done? And just approaching that work with intention. And I think if your aim is to do this work with the hopes of getting hired by whoever owns those properties, this is also a good approach to take, is to do something that is going to be in some way different or unexpected, or can be elevated maybe above just a simple rehashing of ideas that we've seen over and over. And, fair to do that. I feel like in some cases it's almost impossible not to do that. But we can strive to add something personal to it. We can strive to take it that step further. And I think that ultimately, no matter what kind of work you're doing, that's important, and that we should all be really pushing ourselves and aiming to create very intentional work and to reach beyond the expected and reach for something novel and unexpected. And that in that case, no matter what kind of work you're doing, it's going to succeed. So thanks so much, and I will catch you next time. Holy shit, that was long.